presiding judge, my lord and my ladies, if it pleases you and in keeping with the notices affixed to the walls of this hall, permit me to reintroduce myself. My name is Wamboi, Shadrach Wamboi. I appear for the 9th petitioner. My lord, for the purpose of the court record, we equally have a pending application dated on the 18th day of October 2024. And to assist the Honorable Court, we have filed submissions dated the 29th day of October 2024 and a list of authority dated the event date, the 29th day of October 2024. My Lord, we rise in support of the application as urged by my colleagues and my seniors to confirm the conservatory orders that have since been issued, and in any event, to allow our request to have a suspension of the decision arrived at by the Senate on the 17th day of October 2024. My Lord, we take a very simple approach on the complex matters that lie before you for determination, and the manner in which we look at whether the court should grant or disallow the requests that are prayed is that this Honorable Court is invited by the Constitution to be imaginative. The grant of orders of conservatory orders require that the court goes over and above probably the circumstances that are drawn that have necessitated the filing of a petition before court, so that the court can either, in the words of Article 22, arrest a threat to the violation of a right or a fundamental freedom. My lords and my lady, Doctor, for you to imagine the circumstances that would be if the orders are not confirmed by this Honorable Court, then, my lords and my lady, you must, and I say this with tremendous respect, reflect on the assumption of the office of the President Act in order for this Honorable Court to be alive to the prejudices or the prejudice that the petitioner and the Honorable Deputy President Ragathi Gachagua will face if the orders sought are not confirmed. My lords and my lady, we make the submission that to disallow our application will lead to a wastage of public resources, which this court is joined under Article 201D. My Lord, this court is empowered or given the obligation under Article 201D of the Constitution to ensure the prudent and responsible way of the use of public resources. So that, my lady and my lords, the denial of the reliefs that we seek will automatically prompt the swearing in of the person of Professor Kithure Kindiki to assume the office of the Deputy President Ragathi Gachagua. My lady and my lords, pursuant to Section 12 of the assumption of the office of the President, this must be done first within the capital city of the Republic of Kenya, which is in Nairobi, and secondly, on that date when we are supposed to have the swearing in of the Deputy President, must be a public holiday. My lady and my lords, while being treated to a public holiday might not seem to be a bad thing, as it will give the court and the councils an opportunity to rest. It's a bad thing, for one, that firstly, Kenyans who live from hand to mouth will have to take a rest. Secondly, at a time when this honorable court is expected to be doing its business, this honorable court will be forced, my lord, to retire and perhaps to add on to the backlog of cases that we face in the Republic of Kenya. So that, my ladies, my lords, as I conclude my very humble submissions, so that I can pave the floor to my senior, is, my lords, you have an opportunity of arresting a situation that will lead to the use of public resources in a public ceremony that may, in the fullness of time, end up being declared as unconstitutional for the very grounds that we will be persuading you when we come to making arguments in support of the petition that lies before court. My lords, that should be all from me. I will pave the floor to my colleague Wanjiku.
Thank you.
Thank you for the 9th petition. Thank you.
Who appears for who? Because we may have, I do not know how many advocates are supporting. We may sit here to the end of time, because each person is taking 5 minutes, and my concern is that the advocates who are appearing for the same client taking 5 minutes each, then we do not know what we're doing.
You are there for which party?
For the 9th respondent, for the 9th petition.
The same person?
Yes.
You had 5 minutes to start in the two of you. Mr. Rajib, Wamboi has taken more than that.
My lord, sorry.
Because I'm for the second petitioner.
Yes.
My name is Timoto Wanjiru Makazi, Estimate Company Advocate from Kilgoya. And on behalf of the second petitioner, I wish to say that we support the application for conservatory order to remain in force. And the reason why we are saying so is that if you look at our petition, the prayers that we are seeking.
Sorry, madam, with your permission, I'm sorry, because Mr. Model was submitted, and it was our understanding that for the 9th petition, because she did not represent the 9th petitioner, it was our understanding that the minutes that were allocated to us initially, Mr. Shashra from where has taken, and we were to compress the state so that all parties appeared, because we were 4 of us, was to iron out those issues and submit, because then we submitted on one point. So that before she submits, we're requesting kindly for accommodation so that we can air 1 or 2 issues that were left on the channel. Because I was to do a minute, and Mr. Omari was to do another minute as we conclude for the petition. We're sorry about that, so that when she takes up, she'll take it up from a standpoint.
Does it also not bother you that most of the points or the principles you are putting forth have already been put forth even more eloquently?
My lord, that much we agree, but there are 1 or 2 issues that were left out. That's why we wanted permission so that we can air all those.
I think we still believe in the old doctrine that a council can stand up and say that I adopt wholly the submissions of a council who has gone before them. Because I think these arguments have been probably put very eloquently, and we have recorded them.
Well, it must be the direction, my lord.
But I'll give you 2 minutes.
2 minutes.
After Ms. Timoto has finished.
We are most of that. We share 1 minute each with Mr. Mari.
People are yet to come, including the respondents. I hope you take note of that. There's no need for a petition. This will be none.
the reason why we are in support of the conservatory orders remaining in force is that when Justice Richard Mongo was issuing these orders for Kilgoya Law Court, he had in mind petition E013 and petition E014. So he knew very well what he was doing because we appeared before him several times and we tried to stop the impeachment proceedings. However, it was not possible and he consolidated the files. Therefore, if you look at our petition E013, what we are asking for is an apology by the Deputy President of Kenya, Honorable Ragathi Gachagua. So if these conservatory orders are lifted, what are we going to do? Are we not engaging in an academic exercise where our petition has been consolidated, but we are not being given a right to fair hearing, so that the court can understand why we need this apology? And this petition was filed first. It was filed on the 25th September, before the impeachment and after the impeachment. So we are praying that we be given a right to fair hearing. We be heard first. We have nothing against Professor Kindiki. However, once he assumes office, he will now become a deputy president, and therefore we do not need an apology from Kindiki. We need an apology from Ragathi Gachagua. And we need an apology from him when he's at his official residence. Allow me to.
May I just interfere? The petition by Kimoto and company required the deputy president, then, now impeached, to apologize to the National Intelligence Service, NIS, completely overtaken by events. I don't even know why she's here.
That is uncalled for, and I hope the bench will protect me.
I think Ms. Kimoto is slightly before the court.
Yes, thank you. Thank you, Judge, for protecting me, because I almost quoted the paragraph 110 of the disposition of this court, where you assured us that we are going to have a fair hearing. So therefore, thank you, Justice Chalo. So what I'm saying is that, yes. So what I'm saying is that we need an apology from the Honorable Ragathi Gachagua, him being the Deputy President of Kenya. So what we are saying is that we want him, at least we are going to support even the issues of how he was impeached, so that we can get to the bottom of this. And we still have a chance, because he has not left office. And if he has not left office, then we have a chance to be heard in our petition, E013. So allow us to be heard, so that after we are heard, the court can decide if our petition has merit or not. And that's why we are in support of this. And we do not want a kienyeji apology. Our apology is very clear from our pleading, because these utterances he made when he was in office, and they carried weight. What we are insisting is that the NIS team, and especially my client who is affiliated with the NIS, he was affected. In fact, where he stays in Kirinyaga, he cannot stay anymore because of those utterances. So these issues are in our petition. The respondents have not responded. In fact, our petition is unclosed. So therefore, we are insisting, if at the interim stage, the conservatory orders are lifted, what it means is that we will not have a chance to get what we are praying for in the final stage. So it will be, in our view, we will have been overtaken by events at that particular moment. Therefore, when we remove this conservatory order, it only means that we will have a final order in the interim, because now there will be a new deputy president, and we sued Honorable Ragathi Gachagua when he was the sitting deputy president, as deputy president, not as Honorable Ragathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014 on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you are taken and there's just some person. That's all.
Thank you.
Indications and directions earlier that we take 2 minutes. I wish to call upon Waidera, who was on appeal before, so that I donate my time to her in the spirit of national young talent, so that she can also raise a peanut to be paid.
Yes, Waidera, how are you? You have been elected time, so take it and make your submissions.
Thank you, my senior Mr. Nidel. My name is Wanjiku Waidera for the 9th petitioner. And taking off from where my senior Mr. Wanjiku left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have their applications dismissed on account that Parliament has privileged, the respondent, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKIR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts as defenders and protectors of the Constitution have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my lady, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my ladies, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles of this country. Thank you.
Thank you.
We organize with somebody with blood up for that.
I hope you meant 30 seconds.
My Lord, I didn't want to talk, except that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number 2, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The
court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency level. Can that be the position that this court will uphold? I beg that the court extends the grant of the consultative orders. Thank you very much, my lord.
Thank you.
Your Lordship, my name is Atimpa. For the third petitioner, will be sharing time with my colleague, Mr. Watuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by the last experience. So I'll only put into context in our petition. Your Lordship, in the case of Peter Williams, the issue of inherent case is what I want to address, using the ruling that was delivered by Justice Richard Mongo in petition P014. Your Lordship, and this is what the learned judge found upon perusing the document, that on my motion I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 125. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on this question has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petition, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary rule as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrant issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you.
Thank you very much. Very briefly, just making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought, that application is not. That application is not. I say so because the substantive prayer number 2, was that pending the inter partes hearing of this application for setting aside that the orders issued by Justice Chachamwita be valid or set aside. Lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this prayer of the court be pleased to set aside valid or discharge the executive orders issued on 18 October 2024. Followed those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court work easy, there will be no need to consider that application. Having said that, and in view of the previous directions, that this application will be treated as a response to the application for conservative orders, I would just like to make 2 or 3 remarks with regard to the content of that application warrant. And I would just like to mention that paragraph 7 of the supporting affidavit shown by the Solicitor General. Actually, it is in the ground, but then it is reflected in it is in ground number 7. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people, and that there is a conflict between public interest and private interest, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed valid or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president, and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just one thing. I'd like to make a remark, still to make the court work easy, in a petition number 15. And my Lord, again, that application is moot. I had to check the one that is on 6 years, just to be double sure. And the substantive prayers that are sought, prayer number 3, it was an interim order pending in the party's hearing of that application. A lot again, we are beyond that stage. We are already at the party stage of the hearing. So the remaining prayer is prayer number 4. And let me allow me to read it for that this court be pleased to set aside, review, or otherwise vary grant the expunged orders issued on 18th October 2024 by Honorable Justice Mongo Richard Mururu in Kerugoya, Constitutional Petition number 15, pending the hearing and determination of the appeal. My Lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside, pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is not. Turning to the content of that application, in as far as it is a response to the application for conservatory order. Firstly, the decision or the subject of the petition before that court was the proceeding before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than they believed. Again, if you look at paragraph 6 of the supporting affidavit, shown by
Yeah, paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, not. Temporarily set it aside. Pending the hearing of the appeal. My Lord, that is not an appropriate ground because no appeal has been placed before him. At paragraph 7, which is a serious misconception. Yes.
You had very few minutes, I think that is just a few.
Judge, I beg only to judge. Thank you. At paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. One of the reasons why we have the current constitution is to prevent this very mischief. So, we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So, this is a process that
objection that is evidence from the bar.
Well, I'm just picking a paragraph in the supporting evidence.
Mr. Ragathi, please conclude your remarks.
Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My Lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we demonstrate, and the hearing of the petition, is that it's just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we deal with at the petition stage. But all in all, you only have two applications to consider. The one for conservative orders. The one for setting aside the conservative orders, Lord, I've made your heart easy. Most of them, thank you very much.
Thank you.
I'm from Vihiga, and I'd like to.
First of all, we'll just ask for only 5 minutes, please.
Lord, I will do my best, but I promise I will not repeat anything that has been said. My Lord, I'll go straight to the points. One, what is on trial, or what is at stake in the setup of an interim conservatory order? My Lord, I'd like to inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My Lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is the right to a fair trial. My Lord, the components of a fair trial include the tribunal that is independent, it includes the process and the outcome. My Lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking is reinstatement of Deputy President Ragathi Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office,
that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitution that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state, through its action, or any person through their deliberate action, cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But what the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IBC. My lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis. A political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IBC if really there is a political crisis. Finally, my lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wazir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wazir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on, the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wazir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is a question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI, in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner.
May I praise your lordship? I wish to make an application on that.
I want the assurance that we are coming back for the respondent's case.
Yes. Your lordship, that's not correct. My name is Moke Counsel. I'm the third petitioner. I'm the third petitioner, and I understand from your direction on Friday that you will hear all applications for conservatory orders. I'd like to debate on that issue.
Which one is your application?
My application is to be found in petition E057 of 2024.
But that petition is not consolidated.
Hello? It is consolidated, your lordship. The petition was consolidated by an order that was submitted to me on Friday by the deputy registrar, indicating that the two additional petitions have been consolidated. Can you kindly confirm that?
I informed all parties that we continue to receive petitions in this matter. We received petitions as late as yesterday, and by the agreement of those petitions, they receive invariably the same orders and the same prayers. That when a petition comes after we have given directions on other petitions, certainly you don't expect us to go back on the petitions which are not before the court.
Your lordship, if you allow me to read the order that I was given, perhaps it can shed more light. Yes. The order said that application have been consolidated and are required to follow the directions issued on Friday in the other petitions. That's what the order says.
My lord, unless I'm mistaken, we were here to
here applications, two applications in petition, one in petition 522, one in petition 565. Equally, we were here to hear two applications from this side that my Lord directed will be treated as responses to the applications on the other side. If my colleague's file has been consolidated with this file, it does not necessarily follow that his application also has been scheduled for hearing today. And lastly, my Lord, while I'm on my feet, I know we started by giving directions and the court being fair and allowing the parties to drag on and on, but we are concerned on this side that unless the court is able to fix a stop at some point, the other side is committed to proceeding on and on, as I said, until donkeys grow on. And
we object to that. We are not, Mr. Omoke.
Actually, I will speak very briefly. I will take only 5 minutes.
Proceed.
We will do it right away.
We will be disadvantaged slightly with Mr. Omoke's application because he has filed written submissions that he only served on us late last night and we have not responded.
Your Lordship, the submissions I filed, they raise the same cases that we all know about. That's the case of the Tirao Munya, which I believe we are sufficiently aware of. Your Lordship, as you consult, I would like to add that even
Please don't disturb us.
All right, Your Lordship.
We have consulted and we concede to submissions in 5 minutes. On points of law.
These are the directions we are giving. Mr. Omoke, your petition, we give directions that has been consolidated with the petition before the court. But the fact of consolidation does not mean that your application will be hard. However, because your application raises the same issues as the application before the court, we will give you 5 minutes to advance that application. And after that, we will adjourn to come back to consider the rest of the Thank you.
Thank you, Your Lordship. My
I know that
application.
I have a problem. I represent, I'm holding a place for my own friend, Mr. Ashford, Muluki Mubuku. He represents a political party, I represent a political party by the name of Maendeleo Democratic Party. And we filed an application, and our understanding was that Mr. Mubuku we had today. I wanted to check that with the council. Maendeleo Democratic Party.
Which petition is that?
You took your petition, so motion application.
In which matter?
Yes, it was joined in the
Cohort 2 or cohort 1?
E565 2024.
Maendeleo?
Maendeleo Democratic Party.
Well, that's not a party for cohort 1 and
Well, I understand that you will hear me, so probably I should not waste the time.
Maendeleo Democratic Party is not a party in any of the two cohorts.
It's not
It's not a party in any of the two cohorts.
I see, that's interesting. I've got one I will start.
Okay, Mr. Mo.
May I say something again, my
But Camilo, you know you appear in cohort 1 in your own right.
Yes.
Remember that. So if you want to submit in your own right, we will allow you. But for the person who are holding whose brief, you don't appear to see where.
I think I for himself. I don't know.
Just look for him so that you can complete his case.
Yeah.
But in the meantime, let's have this okay.
One final word, I like being human, and I like taking care of the interests of the judges when they are sitting. You are human. Why don't you adjourn tomorrow? No, I'm being human. I know you're working very hard. Also, I'm saying, can you start tomorrow?
My lord, I think the cat is coming now from the back.
Yes, I'm okay. You have 5 minutes.
What's cat now?
I would like to indicate that I support the application of the first petitioner and also submit in support of my own application, which is dated 9th of October 2024. I wish to learn the affidavit sworn on the same day. My submissions filed yesterday, dated 27th of October, the list and panel of authorities. In summary, I would like to state my your lordship, your lordship, presiding judge, your lordship.
What's the date of your submissions?
27th of October. I confirm that I personally attended the public participation at Kiambu Social Hall on 4th of October. And that, from what I observed on that day, I was convinced that I had a responsibility to come before you under Article 3.1 to defend and protect this constitution. That there are serious violations which this court must consider, and in line with the Tirao Munya case, there is public interest at stake. Tirao Munya. There is an inherent, there's a case that we need to consider here, where we must look at all those issues of public participation. Was there public participation, not just on the day when the parliament was conducting it on 4th of October, but even prior to that, under Article 10, I call upon this court to issue the conservatory orders so that we can have an opportunity to be examined Article 10, which for a long time has been seen as though it is something that is aspirational. And I would like to urge the court to consider this to be something that is binding on all persons and all state organs. So such that for the move of the motion in the National Assembly, at the time he was seeking to bring that motion before the National Assembly, he actually was bound by Article 10 to observe all the values contained there, including public participation, go around the country and speak to the people. And I'm here to tell you, my lords and my lady, that the people of this country are angry from what I observed on that day, on 4th of October. And they are sick and tired of how the Constitution is being violated.
Well, as counsel is testifying, maybe he can take to the dock so that we can all have an opportunity to examine him on this testimony that he is.
Yes, in response to Professor's objection, I am a party personally, and I saw an affidavit, and I made all those amendments therein. And if I'm required to be examined, I'm very much happy to do that, if you require that. So perhaps Prof can confirm, and I'll take the dog, very happy. All right, so I'll carry on. He has agreed that he wouldn't like to examine me, so I'll continue my presentation. Actually, at that very same public participation, I did meet some of the people from his famous home, Rubeli, otherwise known as Danbury. And they were very, very unhappy with the way the process was being conducted. And that's why I've come here, not just to speak for myself, but also for all of these people. I would like to tell you, your Lordship and my lady, I'll close my presentation here because I know that we have an opportunity to examine these issues at a later time.
Thank you. These are the directions of meeting. It is now 20 to 3. Yes? Yes. So we can take 45 to come up at half past 4.
I had you to say that
Half past 3. It is now 20 minutes to 3.
That's right.
So we can come back at half past 3.
Only one thing, Your Lordship, that we still have interested parties who might want to support the application. You indicated that it will be coming to the rest of the case.
There's no problem. We are coming back at 10, at half past 3.
Kindly, we have the quorum for E565,
Pole tu sasa. ABC kwa sababu hata sitaki utarejea. Umekuwa wapi leo? Umekuwa bigo wapi? You know. Wacha kamera hapo. Ulikuwa wewe ulipata nini ya media council? Invitation. Diana.
Nilikuwa leo.
Sinaisha kesho. Sorry. Ai. Utatuangushia vitu. Umeenda? Walikuwa na sasa nikuulize mimi